Welcome to Procedural Safeguards, Parental Rights under IDEA Training for Families. This training was created to inform parents of students with disabilities in Orange County Public Schools about the rights afforded to them under IDEA law. The Individuals with Disabilities in Education Act, or IDEA, was enacted by the federal government to ensure that all children with disabilities are provided with equality of educational opportunity, full participation, independent living, and economic self-sufficiency. Originally adopted in 1975 and amended in 2004, the IDEA aims to curb educational problems associated with low expectations and insufficient focus on alternative research, teaching methods, and tools. The major principles of IDEA focus on students' rights to a free and appropriate public education, or FAPE, appropriate evaluations for services and accommodations, an individualized education plan, or IEP, for meaningful educational benefit, and guarantees placement in the least restrictive environment, or LRE, to promote inclusion in the general student population. IDEA also confers rights to the parents of children with disabilities, which will be the focus of this training. Parents are entitled to participation in the IEP process, are guaranteed written notices, and given guidelines and rights for dispute resolution. We will also review concepts within IDEA law that are integral not only to a parent's rights, but also their ability to advocate for their child with disabilities as they matriculate through school. The right to participate in meetings related to their child is one of the most important and powerful of parent rights. Parents have the right to participate in meetings with respect to their child's identification, their child's evaluation, their child's educational placement, and the provision of FAPE, or free and appropriate public education, to their child. Parents or guardians are key members of any group that makes decisions about their child's education, and their input is valuable. IDEA's provisions ensure that, at the discretion of either the school or the parents, other individuals who have knowledge or special expertise regarding the child may be invited to participate in the IEP meeting as members of the IEP team. For example, related services personnel, such as a speech-language therapist or physical therapist, may be invited if appropriate and if they have knowledge or special expertise about the child, the same as a teacher, a specialist, friend, or family member with special expertise or knowledge about the child might be. Who determines if the person to be invited has knowledge or special expertise about the child? According to IDEA, the party, either the parents or the school, that invites the person to be a member of the IEP team. Thus, it's not necessary to demonstrate or prove the person's knowledge or special expertise regarding the child. It's interesting to note the direct connection between the parent's right to participate in specific meetings and groups and the responsibilities that the school system has as a result. The school must notify parents about upcoming meetings early enough to ensure they have the opportunity to attend. It must also schedule the meeting at a mutually agreed upon time and place. When the school notifies parents of an upcoming meeting with respect to their child with a disability, it must indicate the purpose, time, and place of the meeting, indicate who will be attending the meeting, and inform parents of IDEA's provisions regarding the participation of others on the IEP team who have knowledge or special expertise about the child. If neither parent can attend the IEP meeting, the school must use other methods to ensure their participation, including individual telephone calls or conference calls. Yes, the school may hold the meeting without the parents attending if it's unable to convince the parents to attend. In this case, The school just documents its attempts to arrange a mutually agreed upon time and place for the meeting, such as a detailed record of all phone calls made or attempted and the results of each, copies of correspondence sent to parents and whatever the reply was received, and a detailed record of visits made to the parent's house or place of employment and the results of those visits. IDEA stipulates the limits of the term meeting and what we can consider a meeting that's subject to IDEA's requirements with respect to parent notification and participation. A meeting does not include informal or unscheduled conversations that involve school personnel, conversations on topics such as teaching methodology, lesson plans, or the coordination of service provision, or preparatory activities that school personnel engage in to develop a proposal or a response to a parent proposal that will be discussed at a later meeting. Access to the educational records of their children is often a concern of parents. IDEA and other federal laws protect the confidentiality of your child's education records. These safeguards address the following three aspects: the use of personally identifiable information, who may have access to your child's records, and the rights of parents to inspect their child's education records and request that these be amended to correct information that is misleading or inaccurate, or that violates the child's privacy or other rights. Personally identifiable information refers to information that includes the name of the child, parent, or other family member, the child's address, a personal number, such as the Social Security number or a student number, or a list of personal characteristics or other information that would permit the child's identification with reasonable certainty. With some exceptions, you as a parent must give your consent before the school system may disclose your child's personally identifiable information. These exceptions are specified by policies in your state in keeping with the regulations at Section 99.31 of FERPA, the Family Educational Rights and Privacy Act. IDEA's confidentiality regulations refer directly to FERPA. You have the right to know the policies used in your state regarding the collection, storage, disclosure to third parties, and destruction of your child's personally identifiable information. You should be able to obtain this information on your state's policies from the Director of Special Education in your school district or from the State Department of Education. In keeping with the requirements of FERPA, only certain individuals, in addition to yourself as the parent, may have access to your child's records. These individuals may include, for example, teachers or administrators of the school or state who have a legitimate interest in the records. The school or other participating agency is obligated to keep a record of all interested parties who have access to your child's educational records that are collected, maintained, or used under Part B of IDEA, with the exception of parents and authorized employees of the agency. This record must include the name of the person who had access to the child's records, the date, and the purpose for which the person was authorized to use the records. IDEA guarantees you as parents the right to inspect and review any educational record of your child that the school system or other participating agency collects, maintains, or uses with respect to the identification, evaluation, and educational placement of your child and the provision of FAPE, free and appropriate public education, to your child. Here are the specifics of IDEA's regulations. Parents can inspect and review educational records with respect to their child's evaluation, identification, and placement, and the provision of FAPE. Parents can request explanations and interpretations of the records. Parents can request copies of the records if not receiving copies would effectively prevent the parents from exercising their right to inspect and review those records. parents can request that their representative be given access to inspect and review the records. Just as the parent has rights and responsibilities, so does the school or public agency. Schools must comply with a parent's request to inspect and review records without unnecessary delay before any meeting regarding an IEP, a hearing or resolution session, and in no case more than 45 days after the request has been made. Schools must respond to reasonable requests for explanations and interpretations of the records. Schools can charge a fee for copies of records made for parents if the fee does not effectively prevent the parents from exercising their right to inspect and review those records. Schools may not charge a fee for searching for or retrieving a child's records for parents. IDEA and its regulations afford parents the right to examine their child's records, and if they believe they are misleading or inaccurate, or that they violate their child's rights, they may request that their records be amended. If parents believe that the information contained in their child's records is inaccurate or misleading, or that the information there violates the privacy or other rights of their child, they may ask the school system that maintains the information to amend it. The agency must decide within a reasonable amount of time if it is going to comply with the parent's request or not. If the agency decides to refuse the request, it must inform the parents of that decision and indicate their right to ask for a due process hearing on the matter. If you, as a parent, decide to dispute the school system's decision in a due process hearing, you have the right to present evidence that demonstrates why you think the information in your child's records should be amended. You also have the right, at your own expense, to be assisted or represented by one or more individuals selected by you, including an attorney. The hearing must be conducted by an individual who has no direct interest in its result. After the hearing, the educational agency must issue its determination in writing within a reasonable amount of time. That determination must be based solely on the evidence presented in the hearing and must include a summary of the evidence and the reasons for the determination. If the result of the hearing is favorable to you, the school system must amend your child's records and inform you in writing that it has done so. On the other hand, if the result of the hearing is that the information about your child is not inaccurate or misleading, or does not violate your child's privacy or other rights, then the school system must inform you, as parents, that you have the right to add a statement to your child's records commenting on the information that has been under dispute and presenting the reasons you do not agree with it. The district must attach your statement to the records and maintain it there as long as the agency maintains the records. If your child's records, or the part that's under dispute, is disclosed by the agency to any other person, your statement must also be disclosed to that person. IDEA adds another provision regarding educational records and the inclusion of discipline information in them. The state can require the school system to include in a child's records a statement of any disciplinary action, current or past, taken against the child. This statement must be transmitted to the same extent that disciplinary information would be included in and transmitted with the school records of children without disabilities. The statement may include a description of the child's conduct that gave rise to the disciplinary action, a description of the disciplinary action that was taken, and any other information that is pertinent to the safety of the child and others involved with the child. If the child moves from one school to another, the transmission of any of the child's records must include the current IEP of the child and any statement of current or past disciplinary action taken against the child. Parental rights under IDEA include the right to receive prior written notice from the school each time that the school proposes to take or refuses to take certain actions with respect to your child. Specifically, the school must provide parents with prior written notice each time that it proposes to initiate or change the identification, evaluation, or educational placement of your child, proposes to initiate or change the provision of FAPE to your child, that's free and appropriate public education, refuses to initiate or change the identification, evaluation, or educational placement of your child, or refuses to initiate or change the provision of FAPE to your child. Prior written notice serves as a vehicle of communication between schools and families. It is very important that parents are always well informed about whatever action the school intends to take or intends not to take about their child. Through prior written notice, the school can ensure that parents are up to date on what it's proposing or refusing to do as early as possible so that parents can participate in the school's proposed actions or respond to its refusals. Prior written notice must contain a comprehensive description of the action proposed or refused by the school system. According to IDEA, the notice must include 1. A description of the action proposed or refused by the school. 2. An explanation of why the school proposes or refuses to take action. 3. A description of each evaluation procedure, assessment, record, or report the school used as a basis for their decision. 4. A statement that the parents of a child with a disability have protection under the procedural safeguards and how the parents can obtain a copy of them. 5. Sources for parents to contact to obtain assistance in understanding these provisions. 6. A description of other options that the IEP team considered and the reasons why those options were rejected. And 7. A description of other factors relevant to the school's proposal or refusal. Here is an example of prior written notice, a model form that was prepared by the United States Department of Education. This model form was designed to guide states and schools in developing their own prior written notice. The form reads, Prior written notice under Part B of IDEA. Description of the action the school district proposes or refuses to take. Explanation of why the school district is proposing or refusing to take that action. Description of each evaluation, procedure, assessment, record, or report school district used in deciding to propose or refuse the action. Description of any other choices IEP team considered and the reason why those choices were rejected. Description of other reasons why school district proposed or refused the action. Prior written notice must also include resources for the parents to contact for help in understanding Part B of the IDEA. If this notice is not an initial referral for evaluation, how the parent can obtain a copy of a description of the procedural safeguards. There are 2 occasions when the notice to parents from the school must include additional information. When their child is moving from an early intervention program to school-age special education services, and when one of the purposes of the IEP meeting will be to consider post-secondary goals and transition services for the child. Is your child currently receiving early intervention services under Part C of IDEA? Is he or she moving now to receiving special education services under Part B? This usually happens sometimes around the 3rd birthday. If so, the school must call an IEP meeting in order to develop an individualized education program for your child. If this notice from the school is for the initial meeting of the IEP team for the child under Part B, then the school must also inform you as parents that if you so choose, the Part C coordinator from the early intervention program or other representatives of the Part C system can be invited to the first meeting of the IEP team for the child. The purpose? To ensure the child's smooth transition from one system of services to another. Inviting the Part C coordinator to the meeting is not automatic. It's at the discretion of the parents. If you as parents would like the Part C coordinator or other representative of the Part C system to attend the meeting, share your wishes with the school, who will then issue the invitation. IDEA requires that each child with a disability begin to plan for transition to adult life beginning no later than the first IEP to be in effect when the child turns 14 years old. If this is the case with your child, and one of the purposes of the upcoming meeting is to consider post-secondary or after high school goals and transition services for your child, then the notice provided to the parents by the school must indicate that planning for transition will be one of the purposes of the meeting, indicate that the school will invite the student, and identify any other agency that will be invited to send a representative. The school will need your permission before it may invite that representative. At least one time a year, the parents of a child with a disability must receive from the school system a complete explanation of all the procedural safeguards available to them as parents under IDEA. This explanation is called the Procedural Safeguards Notice. Now we'll examine the purpose and contents of this notice, the times the parent will receive it, and other aspects of this important safeguard. The purpose of the Procedural Safeguards Notice is simple: to inform parents completely about the procedural safeguards available under IDEA. These represent their rights as parents and the protections they have, and their child as well, under the law and its implementing regulations. IDEA states that schools must send the Procedural Safeguards Notice to the parents only one time a school year, except that schools must also give a copy to parents in their child's initial referral for evaluation under IDEA, or when the parents ask for such an evaluation of their child, the first time in the school year that a state complaint is filed, and when the first due process complaint is received in a school year, in accordance with the discipline procedures, and when a parent requests a copy of the Procedural Safeguards Notice. The Procedural Safeguards Notice must include a complete explanation of all the safeguards available under IDEA related to independent educational evaluations, prior written notice, parental consent, access to student education records, the opportunity to present and resolve complaints through procedures for due process complaint and for state complaints, including the timeline for filing a complaint, the opportunity for the school system to resolve the complaint, and the differences between the scope of the two procedures, such as their jurisdiction of authority, issues covered, filing and decisional timelines, and relevant procedures. The availability of mediation, the child's placement during the pendency of any due process complaint, procedures for students who are subject to placement in an interim alternative educational setting, requirements for unilateral placement by parents of children in private schools at public expense, due process hearings, including requirements for disclosure of evaluation results and recommendations, appeals at the state level, if applicable at the state, civil actions, including the period of time in which to file such actions, and attorney's fees. In addition to providing this explicit information, the Procedural Safeguards Notice must be written in understandable language. Under IDEA, the Procedural Safeguards Notice, and for that matter, the prior written notice, must be written in a language understandable to the general public and provided in the native language of the parent or in another mode of communication that's used by the parent unless it is clearly not feasible to do so. If the native language or other mode of communication used by the parent is not a written language, then the school must take steps to ensure that the notice is translated orally or by other means to the parent in his or her native language or other mode of communication, that the parent understands the content of the notice, and that there is written evidence that these requirements have been met. IDEA says the parent of a child with a disability may elect to receive the notice by email if the school makes that option available. Parents can contact the Parent Support Liaison, the school district, or district staffing specialist, or the OCPS ESE district department for further explanation of the procedural safeguards. If you, as a parent of a child with a disability, do not agree with the results of the individualized evaluation of your child as conducted by the school system, you have the right to obtain what is known as an independent educational evaluation, or an IEE. This means that you may ask that a professional, competent evaluator who is not employed by the school system conduct another evaluation of your child. If you request an IEE of your child, the school must provide you with information about where you can obtain such an evaluation. You have the right to request that an IEE at public expense. This means that the school system would pay for an entirely new and independent evaluation of your child. The school may grant your request and pay for the IEE, or it may file a due process complaint and request that a due process hearing happen to demonstrate that its own evaluation was appropriate. The school may ask you why you object to its evaluation, but it may not require that you explain or cause unreasonable delays in providing the IEE at public expense or in initiating due process to defend its evaluation. If the school initiates due process and the final decision of the hearing officer is that the evaluation of the school was appropriate, you still have the right to an IEE, but not at public expense. If you have an IEE conducted of your child, you will have to pay for it yourself. Sometimes, as part of a due process hearing, the hearing officer will ask that an IEE be conducted of the child. If this happens, the evaluation must always be conducted at public expense. When an IEE is paid for with public funds, it must comply with the same criteria that the school system uses when conducting an initial evaluation of a child. The school must tell parents what those criteria are, such as the location of the evaluation and all the qualifications of the examiner. These criteria must be the same as those used by the school system for its own evaluation to the extent that these are consistent with the parent's right to an IEE. Nonetheless, the school system may not impose other conditions or deadlines with respect to conducting the IEE at public expense. As a parent of a child with a disability, you should know that you have a right to only one IEE at public expense each time the school conducts an evaluation of your child and you disagree with the findings of that evaluation. Of course, you always have the right to have your child evaluated independently at your own expense. But please note, when the same tests are repeated in short periods of time, the validity of the results decreases. If that evaluation complies with the criteria used by the school system, the results must be considered by the school system in making any decision with respect to providing your child with a free, appropriate public education or FAPE. The results may be presented as evidence in a due process hearing. One of parents' most important rights is the right to give or not give their consent for certain actions of the school system with respect to their child with a disability. When the term consent is used in IDEA, or the term parental consent, it has the same meaning as the term informed written consent. It means that the parent has been fully informed regarding the action of the school system for which parental consent is being requested. Consent means that A, the parent has been fully informed of all information relevant to the activity for which consent is sought in his or her native language or through another mode of communication. B, the parent understands and agrees in writing to the carrying out of the activity for which his or her consent is sought, and the consent describes the activity and lists the records, if any, that will be released and to whom. And C, the parent understands that granting of consent is voluntary on the part of the parent and may be revoked at any time. If a parent revokes consent, that revocation is not retroactive. It does not negate an action that has occurred after the consent was given and before the consent was revoked. The use of prior written notice ensures that parents have the information they need to give informed consent. Informing the parents fully is one of the purposes of prior written notice, which is why the notice must include a comprehensive description of the action proposed by the school system. There are certain times when the school system must ask for and receive your permission as a parent before it can take certain actions. These include before conducting an initial evaluation of your child, before conducting a re-evaluation of your child, before providing special education and related services to your child for the first time, and before inviting representatives of other agencies to participate in IEP team meetings where the transition of the child to adult life will be discussed. There are two ways in which you can refuse to give your informed written consent: when you don't respond to the school's request for your consent, or when you explicitly refuse to give your written consent. So what happens then? What happens will depend on the reason for which the school was seeking your consent as a parent in the first place. If the school's request for your permission was to conduct an initial evaluation or re-evaluation of your child, IDEA states that the school may, but is not required to, pursue the initial evaluation of the child by utilizing the procedural safeguards in Subpart E, including the mediation procedures or the due process procedures, except to the consent inconsistent with state law relating to such parental consent. The school system does not violate its obligations if it declines to pursue the evaluation. These provisions of IDEA only apply if the child is enrolled in or seeks to be enrolled in a public school. If the child is enrolled in a private school at parents' expense, or if the child is being homeschooled by the parents, the public school may not use the procedural safeguards of IDEA to override the parent's refusal to give consent. If the school seeks the parents to give consent for the first time that special education and related services are provided to the child, and the parents do not give their consent, the school may not use IDEA's procedural safeguards, including mediation or due process, to obtain their agreement or to obtain an order that services may be provided to the child without their consent. As a result, the child will not receive special education and related services as part of his or her public education. For youth with disabilities, it's important to plan ahead and prepare for life after high school. Each time that the IEP team intends to talk about transition services for the youth with disabilities, the student must be invited to attend the IEP meeting, and his or her preferences and interests for the future must be taken into consideration. Employees of outside agencies may also be invited to the IEP meeting where transition planning will occur. This is especially important if an outside agency may be responsible for providing or paying for the transition services the student needs. However, before these representatives may be invited to the IEP meeting, the school must ask for and receive the parent's consent or the consent of the youth if he or she has reached the age of majority. You may wonder why consent of either the parent or the youth is necessary at this point. The answer is, in order to protect the confidentiality and privacy of the youth, during the meeting, representatives of other agencies will have access to the adolescent's educational records and information that permits his or her personal identification. This information may not be disclosed without the consent of the parents or the consent of the youth who has reached the age of majority. It's important to recognize that there is a difference between your consent as a parent and your agreement as a parent. In the school life of your child, there are many occasions when you and the school system can agree to take certain actions for the benefit of your child. Usually this is done orally, and that's sufficient. But an oral agreement is not sufficient when parental consent is required. Consent must be in writing. Finally, we come to the last of the IEP components, the transfer of rights at the age of majority. This component is only needed in the IEPs of some students, as you'll see. The relevant IEP-related provision within IDEA requires the following: the transfer of rights at the age of majority, beginning not later than 1 year before the child reaches the age of majority under state law. The IEP must include a statement that the child has been informed of the child's rights under Part B of the Act, if any, that will transfer to the child on reaching the age of majority. The age of majority is the legally defined age at which a person is considered an adult with all the attendant rights and responsibilities of adulthood. The age of majority is defined by state laws, which vary by state. Thus, when people use the term age of majority, they are generally referring to when a young person reaches the age where one is considered to be an adult, which is 18 in the state of Florida. At this juncture in a child's life, the state may transfer to that child all or some of the educational rights that the parents have had up till that moment. This means that in Florida, the rights and responsibilities that parents have had under IDEA with respect to their child's education will belong to that child at the age of majority. Beginning at least 1 year before the child reaches the age of majority, the IEP must include a statement that that child has received notice and been told about the rights, if any, that will transfer to him or her at the age of majority. A state may provide that when a child with a disability reaches the age of majority under state law that applies to all children except for a child with a disability who has been determined to be incompetent under state law, the public agency must provide any notice required by this part to both the child and the parents, and all rights accorded to the parents under Part B of the Act transfer to the child. All rights accorded to parents under Part B of the Act transfer to children who are incarcerated in an adult, juvenile, state, or local correctional institution. And whenever a state provides for the transfer of rights under this part pursuant to paragraph A1 or A2 of this section, the agency must notify the child and the parents of the transfer of rights. The state must establish procedures for appointing the parent of a child with disabilities, or if the parent is not available, another appropriate individual to represent the educational interests of the child throughout the period of the child's eligibility under Part B of the Act, if, under state law, a child who has reached the age of majority but has not been determined to be incompetent can be determined to not have the ability to provide informed consent with respect to the child's educational program. While these provisions may appear redundant, they actually aren't. These provisions relate to informing both the child and the parents of any transfer of rights that has occurred when the child has reached the age of majority in the state. The provision stipulates in the IEP that not later than 1 year before the child reaches the age of majority, he or she was informed of any rights that will transfer upon reaching that stage. Moreover, the provisions fall under the umbrella of procedural safeguards and include the special rule for children who have reached the age of majority but who do not have the ability to provide informed consent with respect to their educational programs, although they may not have been determined to be incompetent. By state design procedures, the educational interests of these children would continue to be represented by the children's parents during the entire time of their eligibility under Part B of IDEA. Should the parent of such a child not be available, another individual would be directly appointed to represent the child's educational interests. So while this special rule relates directly to the transfer of rights to the child at the age of majority, it also serves an exception to the transfer of such rights. IDEA does not specify the manner in which schools must inform students of any rights that will transfer to them upon reaching the age of majority. This is a matter best left to states, districts, and IEP teams to decide based upon their knowledge of the child and any unique local or state requirements. There are times when parents and schools simply do not agree on some issue affecting a child's education. They may try informal approaches to resolving the conflict, such as reviewing and revising the child's IEP or holding a facilitated IEP meeting. When these don't result in agreement on what represents an appropriate education for a child, the law provides several approaches that parents and schools can use to help resolve the dispute. If the dispute is with an individual, such as a teacher or staffing specialist, always try to resolve the dispute with the individual first. Then, utilizing the chain of command of organizational structure, contact that individual's direct supervisor, in these cases, the school principal, and then proceed up the chain of command. In all cases where family and school disagree, it is important for both sides to first discuss their concerns and try to compromise. There are several less formal ways in which parents and school staff might attempt to work out disagreements regarding a child's special education program. The first of these is to review the child's IEP. A second is to hold a facilitated IEP meeting. Under IDEA, the school system, also referred to as the public agency, is responsible for determining when it is necessary to conduct an IEP meeting, and the child's IEP team is responsible for reviewing the child's IEP periodically, but not less than annually, and revising the child's IEP if appropriate. In addition, the parents of a child with a disability have the right to request an IEP meeting at any time. What kind of disputes might be resolved through an IEP review meeting? After the annual IEP review has taken place, if a parent has concerns about his or her child's rate of progress, the appropriateness of the services provided to the child, or the child's educational placement, it would be appropriate for the parent to request that the IEP team reconvene. At that meeting, the parent and the public agency can discuss the parent's concerns and hopefully, as collaborative members of the IEP team, work toward a solution that is agreeable to all. The solution doesn't have to be permanent. It's not uncommon for IEP teams to agree on a temporary compromise. For example, to try out a particular plan of instruction or classroom placement for a certain period of time that the child's IEP is in effect. During or at the end of that period, the school can check the child's progress. Team members can then meet again and discuss how the child is doing, how the temporary compromise addressed the original concern, and what to do next. The trial period may help parents and the school come to a comfortable agreement on how to help the child. Because parents and the public agency are partners in ensuring the child is provided an appropriate education and sometimes will be working together for many years, in some cases the child's entire school career, it is in everyone's best interest, especially the child's, that the IEP team members communicate with one another respectfully and honestly. Another informal approach to resolving disputes between parents and schools is IEP facilitation. The IEP facilitation is not mentioned in IDEA and is not one of the dispute resolution options described in the law's procedural safeguards. However, it is being used to help IEP teams reach agreements in special education decision-making. There are probably others as well, but IEP facilitation is an approach on the rise. Some state educational agencies, or SEAs, provide parents and school districts with the option of facilitated IEP meetings. When relationships between parents and schools are strained, facilitated meetings may be beneficial. It's important to remember, though, that this approach is not required or addressed under IDEA and may not be available in your school district. A facilitated IEP team meeting is one that includes an impartial facilitator. The facilitator is not a member of the IEP team, but rather is there to keep the IEP team focused on developing the child's program while addressing conflicts as they arise. The facilitator can help promote communication among IEP team members and work toward resolving differences of opinion that may occur concerning the provision of a free, appropriate public education to a child. The facilitator helps keep the IEP team on task so that the meeting purposes can be accomplished within the time allotted for the meeting. The IEP facilitator can help support the full participation of all parties. The facilitator does not impose a decision on the group. The facilitator clarifies points of agreement and disagreement and can model effective communication and listening for the IEP team members. When disagreements arise, the facilitator can help encourage the members to identify new options. Most importantly, the impartial facilitator ensures that the meeting remains focused on the child. IDEA does not address IEP facilitation. This means that there is no requirement in IDEA for school systems to provide an impartial facilitator for IEP team meetings. While the use of IEP facilitation has become more popular, facilitators may not be available in all school districts and are not required. However, the State of Florida Department of Education provides IEP facilitation for families. If parents in the school still cannot reach an agreement, it's good to know that IDEA includes specific and formal ways for them to resolve the conflict. These are mediation, filing a complaint, and due process. In mediation, parents and school personnel sit down with an impartial third person called a mediator and talk openly about the areas where they disagree and try to reach agreement. Mediation provides a positive, less adversarial approach to resolving disputes between parents and school systems. With the assistance of a skilled and impartial mediator, the parties involved in the dispute can communicate openly and respectfully about their differences as they try to reach accord and compromise. The decision-making power resides with the participants in mediation. IDEA requires that the mediation process meet certain specific conditions as follows. Mediation must be voluntary on the part of both parties. Mediation may not be used to deny or delay a parent's right to a due process hearing or to deny any other right under Part B of IDEA. Mediation must be conducted by a qualified and impartial mediator who is trained in effective mediation techniques. The state must select mediators on a random, rotational, or other impartial basis. The state must bear the cost of the mediation process. An agreement reached by the parties must set forth in a written mediation agreement. Discussions that occur during the mediation process must be confidential. They may not be used as evidence in any subsequent due process hearings or civil proceedings. The parties to the mediation process may be required to sign a confidentiality pledge prior to the beginning of the mediation. The public agency must make sure that its representative participating in mediation has the authority to enter into a binding agreement on its behalf. A parent may choose to have a friend or advocate attend the mediation session. And while there is nothing in IDEA that prohibits a parent or public agency from having an attorney attend, the presence of an attorney could contribute to a potentially adversarial atmosphere and may not necessarily be in the best interests of the child. A state complaint may be filed by parents or by an organization or individual, including those from another state. Written directly to the State Education Agency, or SEA, state complaints must describe what requirement of IDEA the school has violated, among other specific things. They must also be signed. Each SEA must develop a model form to assist parents and other parties in filing a state complaint. However, the SEA or LEA, Local Education Agency, may not require the use of its model forms. Another form or document may be used so long as the form or document includes the content required for filing a state complaint. The SEA must either resolve the complaint itself or have a system in place where complaints are filed with the school district and parents can have the district's decision reviewed by the SEA. The school system must be given the opportunity to respond to the state complaint, including making a proposal to resolve the complaint. In most cases, the SEA must resolve the parent's complaint within 60 calendar days. It must issue a written decision that addresses each of the allegations in the state complaint and includes the reason for the SEA's final decision. If the SEA finds that the school system has failed to provide appropriate services, the SEA must address the failure, including corrective action, such as compensatory services or monetary reimbursement, if appropriate to address the needs of a child. When due process is used as a way to resolve disputes, parents in the school present evidence before an impartial third person called a hearing officer, and he or she decides how to resolve the problem based upon that evidence and the requirements of IDEA. Filing a due process complaint is the first step in the process that may lead to a due process hearing. A due process complaint is pretty much what it sounds like: a letter or complaint filed by an individual or organization on matters of conflict related to the identification, evaluation, or educational placement of a child, or the provision of a free and appropriate public education or FAPE to the child. IDEA requires school systems, called public agencies, to have procedures in place that make due process available to parents and public agencies to resolve a dispute involving any matter arising under Part B. Due process complaints must allege a violation that occurred not more than 2 years before the date the parent or public agency knew or should have known about the alleged action that forms the basis of the due process complaint. The complaint must include specific information as follows: the child's name, the address where the child resides, the name of the school the child is attending, a description of the conflict, and a proposed resolution of the conflict to the extent known and available to the person filing the complaint. The information contained in the complaint must be kept confidential. The party filing the due process complaint must provide a copy to the other party and forward a copy to the SEA. A party may not have a hearing on a due process complaint until the party or the attorney representing the party files a due process complaint that meets these requirements. An LEA has specific, time-sensitive responsibilities to carry out when it receives a due process complaint. For example, within 15 days, the LEA must convene a resolution meeting unless the parties agree to use mediation or waive the resolution meeting. The purpose of the meeting is to give the parties the opportunity to resolve the issues in the due process complaint without holding a due process hearing. If the resolution process does not succeed in resolving the dispute, the parties progress to a due process hearing, where an impartial trained hearing officer hears the evidence and issues a hearing decision. During this hearing, each party has the opportunity to present their views in a formal legal setting using witnesses, testimony, documents, and legal arguments that they believe are important for the hearing officer to consider. Since the due process hearing is a legal proceeding, a party will often choose to be represented by an attorney. Within 45 days of the resolution period expiring, a final decision must be reached at the hearing and a copy of that decision mailed to each of the parties unless the hearing officer grants a specific extension of this time period at the request of either party. If the hearing officer's decision is not appealed, it is final. The LEA must implement the decision as soon as possible. Hopefully, this chart can help to provide a roadmap for parents engaged in the dispute resolution process. Stage 1 is always prevention. Maintaining good communication with educators and school personnel, attending or participating in parent training and joint training opportunities, and participation in the school or county PTA and SAC committees create opportunities for parents to build collaborative relationships with the people involved in their child's education. In this stage, parents and classroom teachers have the most flexibility and control to solve issues. Stage 2 is the first stage of disagreement. The first attempts to solve the problem are with a parent-teacher conference, consulting with the principal, calling an IEP meeting if applicable, and making sure you are documenting the issues in writing and contacting the district ESE parent liaison for parent-to-parent assistance. At stage 2, parents in the school are still flexible, but the classroom teacher, once the principal has been contacted, is now going to act under the direction of the principal in regard to the issue at hand. Most disputes can be resolved at stage 2. Stage 3 continues to follow the chain of command to reach a resolution. This means that the parent has contacted the learning community administration and support and then reached out to the ESE district office for support. The parent can then reach out to Florida Bureau of Exceptional Education Student Services to request a facilitated IEP meeting. The district and the learning community administrators will use informal mediation through meetings, emails, facilitated IEP meetings, and a state-appointed mediator in order to resolve the dispute. This is the final step of the informal process, so there is still some flexibility, but now the school-based personnel are going to act under the direction of the learning community and district administrators. Stage 4 is the implementation of dispute resolution as provided within the procedural safeguards of IDEA. Resolution meetings, formal mediation, state complaints, and due process hearings happen in Stage 4. These are formal and fixed processes for dispute resolution that do not allow for much flexibility. A third party appointed by the state, usually a mediator or magistrate, controls the process and renders a final decision. It is important to note that a settlement between the opposing parties can still be reached at any point prior to the final decision. Stage 5 is the review and possible appeal of the final decision. Lawyers from both parties are moving the case through the state court system to the federal courts. There is also the possibility that the outcome of the case may lead to state or federal legislative action based upon the finding of the court. This concludes the OCPS parent training for procedural safeguards. Thank you for your participation. To gain more information and resources about IDE law and procedural safeguards, please see the training module links and resources on the Parent Support Parent Trainings page.